Criminal Code. The main outstanding problem is the overhaul of criminal law. The Law Commission collaborated with three prominent scholars to develop the Penal Code, which was written in 1985. Part 1 addressed the basic concepts of criminal justice, while Part 2 dealt with particular offenses which were divided into 5 chapters comprising similar offenses, for example, offenses against a person. The crimes protected by the code is estimated to constitute between 90 and 95% of the operation of the criminal courts. This application has been sent to Parliament but has not been accepted. In consideration of the volume of regulations protected by it, the Law Commission agreed to split it into manageable parts and to draw up draft bills for each of them. The first such legislation was on offenses against a citizen and was written in 1993. This was meant to clarify some of the areas of law which have become quite confusing and which pose problems for the courts and the defendants. In 1994, for example, the House of Lords spent 2 days debating what the words inflict and cause implied in the Offences Against the Person Act 1861. That kind of disagreement can be eliminated by enforcing the law. However, Parliament was unable to find the time required to discuss the plan. Eventually, in 2008, the Law Commission declared that it would no longer attempt to codify federal legislation but would instead work on changing particular fields of legislation. And as the Law Commission issued studies on narrower areas of legislation, the government was reluctant to enforce them. In the 2012 report on legislation, the Lord Chancellor claimed that the study on involvement in crime, 2007, Lawcom 305, and the study on fraud and attempts, 2009, Lawcom 318, were not focus areas and will not be enforced during the lifespan of the new Parliament, which would continue until 2015. Royal Commissions. In comparison to full-time agencies, special boards or judicial commissions are set up to study and comment on a particular field of law. They are discarded after their mission has been accomplished. Such royal commissions were regularly used from 1945 to 1979, but from 1979 to 1990, when Margaret Thatcher was Prime Minister, none of them were created. There was a switch to the usage of these commissions in the 1990s. Many royal commissions also contributed to major reforms in the law. The Royal Commission on Police Practice, the Phillips Commission, concluded in 1981 and several of its findings were adopted by the Police and Criminal Evidence Act of 1984. However, as the Pearson Commission on Personal Injuries stated in 1978, the government will not necessarily rely on advice. With the Runciman Commission, Royal Commission on Criminal Justice, reporting back in 1993, the government put out several, but not all, of the recommendations. Throughout 1999, the Royal Report, Wickham Report, examined whether the House of Lords should be changed. This has been largely introduced by the legislature, but a complete restructuring of the House of Lords is still awaited. Reviews by judges. Apart from the actual royal commissions, courts can be asked to undertake an inquiry into the specific fields of law. Notable examples of this have been the Wolf Committee on Civil Justice, which led to significant policy changes of the court system in 1999, and the review of the criminal justice system by Sir Robin Auld in 2001.